Hello, I'm Professor Scott, and today I'm going to give you an overview of the IRAC method, which many people use when briefing legal cases. IRAC is also a helpful way of analyzing complex problems. We will be using it a lot in our class, and I think you'll find that it's a helpful way to structure your professional writing, whether you're using the method to draft a memo or an answer to an essay question. IRAC stands for Issue, Rule, Application, and Conclusion. Now, to illustrate how you'll use this technique, I'd like to use a simple scenario from sports. Imagine that there are two teams playing a game of volleyball. One team, we will call them the green team, is trying to hit the ball over the net. The other team, the blue team, is trying to stop the ball from coming over the net. Imagine that one of the players on the green team manages to hit the ball and get it past the blue team. The green team says they have scored a point. The blue team says, wait, you hit the net while you were hitting the ball. There's no point. So, does the green team get the point? Of course, we can't answer the question unless we know the rules of volleyball. Imagine you are the referee in this case. To decide if the green team gets a point, your first step will be to figure out what the rule is regarding touching the net while playing. Let's say you check the rule book and it tells you that a player may not touch the net while hitting the ball. That's good, but you need one more piece of information before you can make your decision. You need to know if the green team really hit the net. If you don't know that, you can't apply the rule to this situation. So, to figure out if the green team scored a point, we need two different types of information. The first piece of information is the rule that should be applied when a player hits the net while hitting the ball. That rule will be the same no matter what teams are playing or when the game is played. The rule is not specific to this particular game. On the other hand, we need some information that is specific to this scenario. Did the player really hit the net while she was hitting the ball? Let's imagine the video footage shows that she did. This is a fact, not a rule. In order to figure out if the green team gets a point, we needed to know both pieces of information. We needed to know what the rule was, and we also needed to know what the facts were. Once we have both pieces of information, we can apply the rule to the facts. Then we can reach our conclusion. So, if I was using the IRAC method to analyze this case, the issue would be, did the green team get a point? The rule would be, a player may not touch the net while hitting the ball. The application would be, in this case, the player hit the net while she was hitting the ball, which the rule says means she did not get a point. The conclusion is, no point for the green team. While we are briefing legal cases, we use a very similar method. First, we need to know what the primary question is that the court is being asked to answer. Then we will need to determine the rule that the court will use to answer the question. Next, we need to know the facts to be applied to the rule. Once we have applied the facts to the rule, we can reach our conclusion. Generally, cases will follow a similar format. Usually, the court will start by explaining what happened in a lower court if this case is on appeal. Next, the court will describe the key facts of the case. Then, the court will usually give you an idea of what rule of law they will be applying in this case. Remember, judges went to law school too. They learned how to use IRAC just like you are. After the court has explained the rule, it will apply the facts to the rule to reach its conclusion. Take your time while you are reading legal cases. Legal cases can be very complex and you may need to read them more than once. When you're reading a court case, I suggest you ask yourself some key questions. First, ask yourself, what do the parties want? Then, consider what the key facts of the case are. See if you can decide what question or issue is before the court. You may want to use different colored highlighters to help you keep all of the information straight. For example, you may want to use one color for the facts, one color for the issue, a different color for the rule of law, and a different color for the application. Now, let's look at your first case. Take out a copy of the case Crummy v. Morgan. You can find this case on the Canvas website in Module 1. To start, when you're reading the case, you will see at the top of the page what we call the citation. This is the part of the case that tells you who the parties are, what court is hearing the case, and when the case was decided. The names of the parties in this case are Crummy and Morgan. Crummy is the plaintiff. The plaintiff is the party who brought the lawsuit. He is the one who is doing the suing. The defendant is Morgan. He is the one who's being sued. After the words Crummy v. Morgan, you see the words Court of Appeals of Louisiana, First Circuit. This is the court that's hearing the case. From this part of the citation, we can tell that this case is being heard in a state court in Louisiana. This number is the citation that we would use to find the case in an online database or from Google. Now, if you haven't already done so, take a few moments and read through the case carefully. Look for each of the items I mentioned earlier. See if you can brief this case using the IRAC method. Here's a few suggestions to help guide you. The issue should be a question, preferably one sentence long. This is the question the court is being asked to answer. This is like the issue in the volleyball case where the question was, did the green team score a point? The application section should be the longest part of your case brief. It may be a full paragraph or even longer if the case is very complicated. The conclusion should be very short. It should be one sentence that answers the question asked in the issue. Go ahead and give it a try. When you've finished, resume the video. Now, let's look at this case together. In this area, the court summarizes the main facts of the case. In this line, we get a hint that this case is about personal jurisdiction. But make sure that you read the full case before you write your issue statement. Here is the rule of law. You can see it is a little long. You will want to summarize this in 2 to 3 sentences and put it in your own words. This is the defendant's position. It's interesting, but we want to know what the court held, not what the defendant argued. Here is the application section. In these paragraphs, the court takes the rule of law and applies it to the facts. This is the court's conclusion. The court explains its conclusion here. You should always try to put the court's decision in your own words. Don't just copy down what the court said. So here's how I would brief the case of Crummy v. Morgan. Keep in mind that your brief may be longer. This is just a summary example. First, I would give a summary, a citation for the case. Next, I would summarize the facts. In this case, Daniel Crummy, who is a Louisiana resident, is suing the defendant Morgan, who is a resident of Texas. Mr. Crummy bought an RV from the defendant in Texas. He's suing in a court in Louisiana because the RV was defective. What is the issue in this case? The issue was whether this court had jurisdiction or legal authority over the defendant. The topic of jurisdiction is covered in this week's reading, so hopefully this was a familiar concept. You should know personal jurisdiction is normally a geographic concept. This means that the state where the defendant resides normally has jurisdiction over the defendant. In this case, the plaintiff was suing in a court in Louisiana. This is not the state where the defendant resides. However, the rule of law tells us that a court may exercise personal jurisdiction over a non-resident if they transact business in the state and have certain minimum contacts with the state. In this case, the court explained that there is a sliding scale for jurisdiction when a defendant advertises or sells products over the internet. In the application section of our case, we discovered that the defendants used eBay to accept a credit card from Louisiana and answered questions about the RV by phone while the plaintiff was in Louisiana. The court also noted that the defendants used eBay to extend the market for the sale of their RV. Because of these contacts with Louisiana, the court concluded that jurisdiction was proper in this case. To summarize, when briefing legal cases using the IRAC method, provide the citation, a very short summary of the facts, the primary issue or question before the court, and the rule that the court applied in order to answer the question. Describe the key facts that the court applied to the rule in order to answer the question posed in the issue. Finally, tell us, based on this application of the facts, what did the court rule? In other words, how did the court answer the question posed in the issue? When you read over your brief, make sure that your issue, rule, application, and conclusion all deal with the same area of law. If the issue is whether the court has jurisdiction, the rule should explain when a court has jurisdiction over a particular plaintiff. The application section should apply key facts to this rule. I hope you've enjoyed learning how to brief a case. You will use this skill to complete this week's assignment.